All rise. Scottsdale City Court is now in session. The Honorable Judge Blake presiding.
Thank you. Please be seated. So we're here on State of Arizona versus Gionet, G-I-O-N-E-T, CR 2020-016964. This is oral argument on state's motion to state's petition to revoke defendant's release. Will the parties please announce for the record?
Seth Peterson, appearing for the city.
Zach Thornley, appearing for Anthony Gionet.
Where is the client?
I'm not sure, Your Honor.
How do you mean you're not sure?
I'm not sure where he's at, Your Honor. This hearing was set with only a couple days' notice, and I haven't had a meaningful chance to discuss this or.
Well, have you called him to tell him about today's hearing?
I've spoken to him, yes.
And he's been informed of today's hearing?
That's correct.
So he knows about it and he's just not here?
I can't tell you what.
Well, you can tell me, does he know about today's hearing?
Yes, he does.
He's not here, is that correct?
That's correct.
Okay. Court will not waive defendant's presence. We'll proceed with the state's petition.
Yes, thank you, Judge. Judge, on December 11th, the defendant was released to OR and he was issued release conditions in writing, which he did sign for. Term 2 stipulated that he violate no federal, state, or local criminal law.
Sorry, just real quick. Before we get rolling with all of this, I did want to ask that this be reset, as I had previously filed motions on, because of the time frame of all of this. I haven't had as I mentioned just a minute ago, I haven't had an opportunity to have a meaningful conversation with my client about this, as well as I've asked for the FTR regarding his arraignment. I believe that there may be information in there that is pertinent to this, as well as the fact that this hearing was set immediately after the state filing the motion for this. I haven't had a chance to respond to that at all. So I would ask that this be reset.
Sure. Go ahead.
That's all.
Okay. Well, let me refer you to your motion continue. It doesn't mention any of that. Your motion continue is undersigned counsel recently submitted a request to Scottsdale City Court to disclose video/and/or audio recordings of December 11, 2020 proceedings. The continuance is needed to allow the court to produce and disclose these recordings to the defense. Of course, the court wouldn't. I assume it's just a typo, meaning the state.
Sure.
How would that have anything to do with release conditions?
So, and I did file, I don't know if you can see, but I had filed a motion for reconsideration.
No, it hasn't arrived yet.
Okay.
Again, how does your motion have to do with anything with release conditions?
Again, I'm asking for the FTR for the arraignment so that I can hear what Mr. Gionet was informed during the arraignment.
And why isn't your client here to explain what he thought it was?
I can't tell you.
Okay.
Probably because we had only a few days to prepare for this.
Okay, since the client has chosen not to show up, I'm not going to grant your motion continue. I would have considered it if he had been here to explain his side, but since he's chosen not to, I'm going to hear the argument. If he ever deems to show up to court, he can always explain his side.
Well, what I'm saying is that his side is that we were given a short window of notice and no meaningful opportunity to respond to the state's petition. So,
sure.
So that's why he's not able to be here.
Why did that stop him from coming here, much like you're here?
Because of the notice.
You're saying something precluded him from coming here in 2 days, and you don't know what that is.
Correct.
Okay, I'm not going to grant the motion to continue. Again, if he ever deems to come to court, I will listen to his side, but he knows about today's hearing. He's not here. We have no explanation that you can offer as to why he's not hearing, except for some reason 2 days isn't enough notice to appear.
It's abnormal for the court to set, at least in the other courts I practice in, Your Honor, for the court to set a hearing and require the presence of everyone, especially in today's setting where everything is virtual. I'm happy to get him on the phone.
If he wants to explain to me why he couldn't physically show up today, yes, you can get him on the phone. But that's what I want is an answer is why he physically was precluded from coming here today.
Okay. May I have a moment to call?
Sure.
Okay. Your Honor, I was unsuccessful in reaching him.
Okay. Motion continues denied, subject to re-urging at, once the defendant is located. Proceed, Mr. Peterson.
Thank you. So as a condition of the defendant's OR release in this case, he was ordered in term 2, violate no federal, state, or local criminal law, and in term 3, not leave the state of Arizona without written permission from the court. Now, the state became aware that the defendant was a participant in the Capitol riots on January 6th. In fact, the defendant live streamed his participation in the riots, which we have a couple of clips of if the court would like to see them. In addition to that, the defendant's
Is
participation.
that what the law-abiding part is?
Well, the law abiding, as well as the, don't leave the state without written permission of the court.
Okay.
My understanding, and I didn't see anything in the court record, indicates that there was a request and/or permission to leave the state. In addition, the defendant's participation in the riot was well documented in numerous news articles, including from the New York Times, as well as the New York Post.
What was well documented?
His participation in the riot.
Oh,
He's
wow.
present in Washington, D.C. in the riots on January 6th. So clearly, that would be a violation of the court's order not to leave the state without prior written authorization, and also likely a violation of the court's order that he obey all state, local, and federal laws. So the state is asking for a modification of release conditions, and in addition to the defendant not being present today, also adding to the justification for a request for modification, the state would request that the court issue a bench warrant in the amount of $25,000.
Why 25,000?
What's that?
Why 25,000?
Well, the state's concerned with the defendant's failure to remain law-abiding, as well as his decision just to leave without notifying the court. I can play the clips.
Sure, I understand your request, I just don't understand the amount. You have 2 Class 1 misdemeanors and a Class 3 misdemeanor. It's usually about, when a bond is issued, it's usually about $500 for a Class 1, so that would be $1,000, and then $250 for a Class 3. So why 25,000?
Sure, and back when there used to be a bail schedule, which there no longer is,
Correct.
that might be a standard term.
Right.
Standard bail, once the defendant was arraigned, and often the court would just order that standard bond amount. Well, the defendant, obviously having the privilege of OR, or being released OR, continued demonstrating lawlessness, as well as him not being here, and has obviously demonstrated disregard for the court's order by leaving the state without permission. The state believes that's an appropriate amount. In addition to what I can play in terms of the clips, that also informs my recommendation to the court. So that's the state's request.
Okay, you can play the clips.
And Judge, I can have this marked as State's Exhibit 1.
Okay,
If the court would like to have a record of it.
sure. And this is from his account, allegedly?
This, upon information and belief, this is from his live stream, which was posted on social media.
Okay.
And so there are 2 clips, each are 2 minutes in length.
And just
You can listen to all U.S. Senate right here.
Just a second, go ahead.
for the record, I'm going to object to all these things that have not been disclosed to us. And again, this goes back around to my earlier contention that I haven't had a proper opportunity to prepare a defense for today's setting.
Sure. Okay, go ahead.
So Judge, I'll ask to admit State's Exhibit 1 as part of the record,
Okay.
which has the 2 clips.
Any additional objections in addition to the ones you just made?
Your Honor, in terms of, I believe I would also object in terms of foundation. There's nobody here to testify that this is his video, that this is, that that's even him, or that he's, or that this is a real setting, or what have you. In addition to that, I'm objecting to the relevance of it, and I don't see how it's even relevant to today's setting, especially given that we don't know any background information about this video.
Okay. Overrule, you may present.
Judge, also I'm going to ask the court to receive State's Exhibit 2, which is a booking photo from this incident, from when he was released to OR.
And just for the record, when you say this incident, you're referring to this Scottsdale case?
The Scottsdale case, correct.
And any objection to the booking photo?
No objection to the booking.
States 2 is admitted.
Christ is king. Yeah, give Mike Pence on the phone. All right, let's continue the tour of the Capitol. It's a nice floor. Check out the office. I saw a couple ballots in there, yeah. I did. It'll probably take a couple months to count. Yeah. Hello, Bix Department. Let's go. Any other rooms? Oh! Let's check. Hey, it's a fancy one. Hey, we're getting a nice tour of the Capitol. Let's go! That's right. Yeah, I want to see him. Oh, wow. This is a nice one. Yeah, don't destroy everything. Yeah, we're in our house. We don't need to, don't break anything. Just enjoy your time here in your house. You know? Put your feet up, you know? Relax for a little bit. Let's go. Alright, our house. Whose house? Whose house? Whose house? Whose house? Whose house? Let's go. Oh wow, look at this view, guys. Wait, whoa. Yo. This is fucking awesome. This is crazy. So the cops are all and we're in here. Hey, someone shout for me because I can't even see the viewer count. So let's go. This is wild, bro. This is it.
Judge, I have one additional 2-minute clip.
Okay.
Woo! Hell yeah! Let's go. Dude, we're in the Capitol right now.
Underscore signs of
Occupy the Capitol, let's go! We ain't leaving this bitch! I am sleeping in this room. I call this chair. Occupy the Capitol! Yeah. Patriots are in control, baby! Yes! I told you! I told you! Hey, thank you! Shout out to Germany! Thank you! Hey, I told y'all to trust the plan, did I? Did I not? Trust the plan, baby, let's go! Hey, thank you everyone for sharing this video. Let's get this video up. We got over 10,000 people live watching. Let's go! America first! 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 Let's go! Yeah! What are they doing out here? Wait, what is that rope? Are they climbing over the put a flag? Oh, they put a flag. Oh, we put a flag up. Which is better. That's what's up. No, for some reason, that's their reason. Oh, yeah. Yeah, look at that. So all the cops are outside. Weird.
Anything additional from the state?
No, sir.
Okay, do we have a way to pull up the audio from the December 11th arraignment? Can we pull that up so you hear it? And then I'll give you your opportunity to address the issues. What we want to do is pull up the audio from jail court on December 11th. It would have been around 10:31 or so.
Is it 10:30?
It'd be approximately 10:31, because that's when the judge made the notes. You know, it might be a little earlier than that, a couple minutes, that type of thing.
We might have to go a little earlier than that, because she should announce the case or the defendant's name like a couple minutes earlier.
She can take it. This person will take it. So we'll do 27.
This is it.
Yeah.
Are you able to hear?
Is
She
it?
won't come closer.
We're going to send this back to reach out all that information.
Please proceed.
Yes, Your Honor. I think, so the reason why that I wanted to be able to review that, and now we have had a chance to, is that Mr. Giannett was told by the judge twice not to go to Gilligan's, not to consume alcohol or drugs, and not to have contact with the victim. In my contact that I have had with him, he said, "Hey, listen, if the judge had told me, not to leave the state, I would never leave the state." I don't think that the notice that he was given, or that we can see from the audio, was sufficient. In addition to that, in regards to the request from the state, I want to just kind of circle back around with regards to release conditions themselves. The law, the case law, the criminal rules, everything around release conditions is stuff that has been set long before I was born or ever dreamt of being an attorney. And so I think when these things are boiled down, what it boils down to is that release conditions are to ensure that a person is going to appear for court, and that a person is not a danger to the community. Mr. Giannett has absolutely no criminal history whatsoever. This case that's before this court is the only interaction that he's had with the court system for anything criminal whatsoever. And in regards to this particular case, this case, and I believe is going to the court's going to end up seeing that this was a case of self-defense, and that Mr. Giannett did not violate any laws in regards to this particular case. But our statute, ARS 3967, lays out literally lays them out by number, all of the factors for the court to consider: the views of the victim, the nature of the circumstances of the offense charge, evidence the accused poses a danger to the community, all of these things, and virtually none of those are present here in regards to any showing that Mr. Giannett's a danger to the community. Your Honor, I feel that if we had been given more time, Mr. Giannett would certainly be here. He's retained counsel. He didn't retain counsel so that he could run from this case. And I know that in regards to the setting today, that he's not here. But again, if we had been given more time, I feel very certain he would have been here. I have absolutely no doubts that he'll be at any future proceeding that we have that requests his presence here, either virtually or in person. I think that the request for $25,000 is a little outrageous. I think it's way beyond what's necessary, especially for someone with no criminal history whatsoever. And again, I think that the FTR demonstrates that he wasn't told not to leave the state. And so we would ask that, based upon the factors set out in ARS 13-3967, as well as the facts that I've given the court in regards to his status, that Mr. Giannett retain his OR release. Additionally,
That's all, Your Honor.
State, it's your motion.
Judge, just to reiterate, the defendant was ordered not to leave the state without prior written approval of the court. It was in his written release conditions, which he signed for. I just compared the signature to his release questionnaire, and they're certainly the same. So clearly, the defendant had notice of the terms of the conditions of his release. These are standard terms and conditions of release required by Rule 7.3, which simply says every order of release must contain the following conditions. This is an order of release. He was ordered not to leave the state without prior written authorization from the court, not to violate federal, state, or local criminal law. So I'll submit it on my argument, Judge.
Okay. Having reviewed the state's motion, having reviewed the exhibits 1 and 2, having heard the tape from the release conditions, or arraignment, I should say, on the additional charges, having reviewed the release conditions in the file, which do state, as the state says, number 2 condition is violate no federal, state, or local criminal law. The number 3 condition is not to leave the state of Arizona without written permission from the court. The defendant signed that under the acknowledgement of, I fully understand and will comply with all release conditions indicated above, and fully understand the consequences if I violate any of the court order. Defendant knows from 2 paragraphs up on that, the court may issue a warrant for your arrest upon learning of any violation of the conditions of release. After hearing, if the court finds you have not complied with the release conditions, the court may modify the conditions of release. I agree with defense counsel. It was set to a quick hearing because the state requested a summons rather than a warrant for the defendant's arrest. Based on the allegations, I could have issued a warrant for his arrest, but I wanted to give him an opportunity to come in here and address the state's allegations. He knows about today's hearing. We don't know why he's chosen not to appear, other than 2 days' notice isn't enough to get to Scottsdale. I don't know why that would be. That's why I gave him an opportunity to call him to see why in 2 days he wasn't able to come here to Scottsdale, since he's supposed to only be in Arizona. Even if you're in the northern part of the state, you could drive here in less than 2 days. So at this stage, having seen that it appears from his video that he has left the state of Arizona and gone to Washington, I'm not even clear if he's actually returned to Arizona or is still in Arizona. We have that violation of the release conditions. I agree with defense counsel that release conditions are to make sure the person will show up to their trial or their PTC or their TRC or CMC. And the reason most people are presumed to be released OR, which the defendant was, and you give your word you will be there. You also give your word you will not violate federal, state, or local laws, and that you will not leave the state without written permission from the court. There was no written permission. Having violated 2 of the release conditions, it appears, and again, if he ever appears, I would be happy to hear his side of the story and consider that. I do find that there has been at this stage proof presented that the defendant had violated his release conditions. I'm still not convinced that a $25,000 bond would be appropriate in this case. It seems somewhat high. Defense counsel, are you aware of any amount the defendant could make?
Your
An
Honor,
appropriate amount?
I would ask that as was previously mentioned, that the $500 bond be set on these. I think that's, although that schedule may no longer be in place, that there was a reason why that schedule was in place. That's what's reasonable. Additionally, again, he's got no criminal history whatsoever, and I know the court mentioned about violating federal or local laws, but I'm not aware of, and the state's not presented any evidence that he has violated any laws. So, for those reasons, that's why I would ask for a minimal
bond amount.
Sure. Again, it's not beyond a reasonable doubt, but from the video, it appears he is in the capital of the United States of America, trespassing at the very least. And of course, that would be a crime. I don't know under federal law what type of classification that would be or whatever. But again, at this stage, with no criminal history, I don't find that $25,000 would be appropriate. I will set bond in the amount of $3,000. Once you contact your client, if he wants to make an additional argument, I'd be happy to reconsider. But until he comes in and posts the $3,000, there'd be a warrant for his arrest in that amount.
Okay.
But if for some reason you guys want to appear and make another argument, I'd be happy to hear it, to hear his side of the story.
Okay.
The one thing I'm sure you will advise him, though, is if they're looking at another event, he may not want to talk about the events, and I would totally understand that if he didn't, but I want to give him the opportunity if for some reason he did.
Okay. Thank you.
Anything additional from the state?
No, sir, thank you.
Anything additional from the defense?
No, Your Honor.
Oh, and then the other conditions would remain too. Don't go to Gilligan's, no alcohol and no illegal drugs.
That's not a problem, Your Honor. I don't think he does drugs or I don't think.
Oh, I know, but I just,
Yeah.
because I didn't want someone, oh, you didn't mention the others, so are those
Yeah.
gone or something? Okay? Thank you all for coming.
Thank you.
And again, just for the record, I do realize it was short notice, and I do apologize for that, but I didn't want to issue a warrant without at least giving him a chance to give his side.
Thank you, Your Honor.
May I be excused, Judge?
Yes.
If there were other matters on the calendar that you need my input.
Well, there's one